shoot. So more folks will trickle in, I presume, in the next couple of minutes. But we're going to go ahead and jump in. First off, thank you all for joining us today. This is Full Use and Full Enjoyment, a Fair Housing Center of Southwest Michigan training on reasonable accommodations and modifications, broadly about disability in fair housing. And I've mentioned it to some of the earlier folks, but I am working from home today and I do have a dog. He's a very nice boy, but if he begins to bark, I will do what I can to take control of that situation. And thank you all for your understanding. So, before we get too deep into the presentation today, I would like to note that it's for educational purposes only. It's not legal advice, and you shouldn't rely upon it as such. Uh, every situation that you encounter in fair housing is going to be different, and laws vary depending on jurisdiction. So if you do have specific legal questions or questions about how to proceed in a case, seek out, consult with an attorney before doing anything. Another bit of housekeeping, I'd just like to say thank you to the Michigan State Housing Development Authority. It is through their grant that we are able to offer this and other trainings free of charge. So thank you, MISTA. And in case you are unfamiliar with the Fair Housing Center of Southwest Michigan, we are based in Kalamazoo, and it is our mission to eliminate all forms of housing discrimination through fair housing education, enforcement, and advocacy of the fair housing law. And that order is intentional. We figure if we can educate well enough, then we can stop fair housing discrimination before it begins by educating housing providers well enough. And also through education, people can learn to recognize when they may be dealing with housing discrimination. They can bring that to our attention, and then we can advocate on their behalf. We serve the 9 counties of Southwest Michigan. That's Allegan, Berry, Berrien, Branch, Calhoun, Cass, Kalamazoo, St. Joseph, and Van Buren. And we work with renters and home seekers. We work with landlords and property managers. We also work with real estate agents and lenders, and sometimes even going for, excuse me, sometimes even getting into the municipal side of things. And what we do in that capacity is education and outreach. My name is Derek Kusa. I'm our education and outreach director. We engage with complaint intake and case review. We do certain investigations that will target individual housing provider, housing programs, or the market in an area. We help with fair housing enforcement, so gathering evidence for a case, advocating on behalf of our clients, all of these to assist in enforcement. And then finally, we do advocacy and legal referrals. So we can intercede on clients' behalf pending certain conditions. And we are not the only fair housing center. So if you or someone you know is outside of our service area, you can also speak with the Fair Housing Center of West Michigan, who handle the lion's share of Michigan counties, Fair Housing Center of Eastern Michigan, which is under the auspices of Legal Services of Eastern Michigan, Southeast Mid-Michigan, and then finally Metro Detroit. And that is a little bit about the Fair Housing Center. And before we get into the main topic today, which is disability and especially reasonable accommodations and modifications, we're going to go over some fair housing basics. So the first question to ask then is, what is fair housing? And put simply, fair housing is the right to equal and equitable access to housing. And another way to put that is the right to be free from discrimination. And here I've used the phrase at all points of the housing transaction. So the next question that follows is, what is the housing transaction, quote unquote? And then what constitutes discrimination? Now I'm going to say broadly defined or broadly construed a lot in this training today, because as a piece of civil rights legislation, fair housing law is to be broadly construed. And the housing transaction is any process related to buying, renting, maintaining, appraising, or selling a house. the standard of maintenance that you get while you're renting an apartment. This is all part of the housing transaction, as well as certain adjacent services such as homeowners association bylaws and your interaction with them and those who sit on the HOA, as well as your treatment from your landlord if you're living in rented housing, how an appraiser conducts themselves if you're appraising your home. It's not simply the numbers, it's anything to do with the housing, anything that surrounds housing. And so, what then is discrimination? Very broadly, of course, discrimination at its most general is enduring differing treatment based on assumed information. So someone's reacting to characteristics, not facts or behavior. And in fair housing, we need three things to be true for discrimination to be true. One, is there a covered dwelling involved? Two, is there a protected class involved? Three, is prohibited behavior involved? And if you have all three, then you have housing discrimination. So again, the first question we have to ask and to answer is what is a covered dwelling? Much like the housing transaction, covered dwellings should be construed broadly. Pretty much anywhere you live, anywhere that you deal with the place that you live, these are all covered dwellings. So we have houses and condominiums, apartments, transitional housing and shelters for the unhoused, college dormitories. You'll notice as well, I've got homeowners associations and public housing authorities. These aren't dwellings as such, but the rules and regulations and behavior that are part of how these associations and authorities conduct themselves are technically covered by fair housing. We also have housing construction sites, places where these dwellings may not yet exist, but will. These are all covered dwellings under the Fair Housing Act. There's also an interesting edge case when you think about something like a hotel or motel. Because that's a strictly financial arrangement, Fair Housing Act usually doesn't apply to a hotel or motel stay. But let's say that you, for whatever reason, are living at a hotel or living at a motel. The Fair Housing Act will apply if you don't have a primary residence to which you can return. Uh, and there are other similar cases that basically, as long as the relationship of that transaction is not strictly financial, like a motel or hotel stay, or there's no other primary residence involved, then fair housing will apply. So those are the covered dwellings. We also have protected classes. Federally, there are 7 protected classes: race, color, national origin, religion, sex, disability, and family status. And then here in Michigan, we add more, and then municipalities can add even further. They can never detract from those federally protected classes. But here in Michigan, we expand the protection of sex to all sexual orientations and gender identities. We also protect marital status, age, and source of income. And we'll have a little bit more on source of income here. Now, each of these protected classes have been written into law through certain regulations or pieces of legislation. And this is by no means an exhaustive list, but the key laws federally begin with the first Civil Rights Act to be passed, which is the Civil Rights Act of 1866. And this specifically delineates race and color as protected classes. It's right off the back of the signing of the, it's right after the end of the Civil War, signing the 14th and 15th Amendments, I believe. And so race and color are explicitly written out in the new property rights of these newly made American citizens. And then the Civil Rights Act of 1968. Title 8 of the Civil Rights Act of 1968 is actually what's known as the Fair Housing Act. And this adds to the Civil Rights Act of 1866, protecting further religion and national origin. Major players in the passage of that are, of course, Martin Luther King Jr., who is a big housing advocate with the Chicago Freedom Movement. Excuse me. as well as groups like the NAACP and the GI Forum. And the GI Forum is especially important in terms of getting national origin protected, as many of the GI Forum were uh, Latin veterans or Latin American veterans, Latinx. Then there's further Fair Housing Amendments Acts, first in 1974 to add sex as a protected characteristic, and then in 1988 to add disability and family status as protected characteristics, protected classes in the federal fair housing law. There's also various executive disorders. You may have noticed that the federally sex is protected, whereas in Michigan, all sexual orientations and gender identities are protected. That comes from an interplay of these executive orders. A Biden administration executive order expanded coverage to all sexual orientations and gender identities, and now we've since truncated back to just biological sex. But here in Michigan, the controlling civil rights law is Elliott-Larsen Civil Rights Act. This was first passed in 1975. Most states are going to have an act similar to this that echoes the Federal Civil Rights Act. The Elliott-Larsen Civil Rights Act is no different. And this in 1975 explicitly protects race, color, religion, national origin, sex, disability, family status, marital status, and age. The Elliott-Larsen Civil Rights Act was updated in 2023 to expand those sex protections. And then I mentioned source of income. Late in 2024, a Senate bill package was passed that incorporated source of income protections in housing. And so with source of income, basically what this means is that if you have income that comes from any legal source that is not strictly employment derived, so things like Social Security, veterans benefits, alimony payments, child support payments, and crucially, housing choice vouchers. Having this other source of income, it now needs to be counted as whole income. It can't be treated as a sort of second class renter if all of your money doesn't come from a paycheck. There are a few other recent changes. I've mentioned at the top, the federal sex protections no longer including sexual orientation and gender identity. And here I have a note about disparate impact, which we won't really be getting into too much today, but this is one of what's called the theories of discrimination. There's discriminatory intent, disparate impact, retaliation, and failure to accommodate. Failure to accommodate will be a big one for us today. But disparate impact is seeing some difficulties in terms of its legal applicability lately. And I was intending to have a firmer set of facts here, but it's still very much up in the air. If you're interested in learning more, you can contact me after this presentation, and I can speak to you a little bit about disparate impact and the public comment period. However, the center will be working to provide information to all of its clients and all of you who join us for these these trainings. We're working to provide more information on these changes as they occur. So that is a very quick crash course in fair house basics. We're going now to get into disability in fair housing. And disability is consistently the most common cited protected class in fair housing complaints. And it's the only protected class where discrimination can exist owing solely to the design of the built or occupied environment. We're going to look at disability in fair housing through a discussion of the laws that underpin discrimination protections. And then we're going to talk quite a bit more about reasonable accommodations and reasonable modifications, which are changes to the environment to help you better live there as someone with a disability. But what is a disability? So, as I've said, as with many aspects of fair housing, disability is broadly defined, and it is a physical or mental impairment that substantially limits one or more major life activities. And I suppose more to the point that major life activity is what's to be broadly construed. I've listed some here. This is, of course, not an exhaustive list. An interesting thing with disability and fair housing is that a person does not actually necessarily need to be disabled for these laws to apply. Uh, that is to say that a person who's protected with regards to their disability under the law is someone who does actively live with a disability or with an impairment that substantially limits one or more major life activity, someone who's perceived as having such an impairment, who has a history of having had such an impairment, or someone who associates with a so defined disabled person. So these extensions exist because, um, as we'll see, the housing rights of disabled people were usually lockstep or slightly lagged their legal labor and employment rights. And major life activity impairing, excuse me, many major life activity limiting impairments are not in fact disabling, but are believed to be so. And the people who have them might be denied employment, might be otherwise shunned, might be denied housing as a consequence of the misbegotten belief that they're disabled. And so these people who are objectively capable of performing as well as someone who's not similarly impaired, um, they it's analogous to otherwise capable workers in the labor force who are discriminated against because of skin color or some other vocationally irrelevant characteristic. And so then extending that from employment law, you extend that same logic to housing for disability protections. Further, not all disabilities are apparent. A person, it might be plainly evident that the person requires the use of a wheelchair, and that person is no more or less legally entitled to disability protections than a person who lives with a less apparent, say, stress disorder. And so we'll move now from uh, what disability is defined as under law into the laws that define it. And there are four key laws. There's the Rehabilitation Act of 1973, also known as the Rehab Act, sometimes referred to as Section 504. The People with Disabilities Civil Rights Act here in Michigan. There's the Fair Housing Amendments Act of 1988, which adds disability to the Fair Housing Act, Title 8 of Civil Rights Act 1968. And then finally, the Americans with Disabilities Act, which is not as relevant to housing, but does have something to say about how we distinguish service and support animals, especially. But we'll go through these laws in turn here. And so the Rehab Act, or Section 504, was the first civil rights legislation protecting disabled people from discrimination. Section 504 prohibits discrimination on the basis of disability in any and all programs that receive federal financial assistance, as well as those programs that are conducted otherwise by federal agencies, including in healthcare, public education, transportation, subsidized housing. Again, the list is not exhaustive. But so Section 504, for example, would cover all health and human services programs and activities funded by the Department of Health and Human Services. That includes hospitals, doctors that accept Medicaid or Medicare, to state child welfare programs. It protects people with all types of disabilities and disabled people of all ages. Excuse me. And this includes older adults who might need assistance with major life activities like walking, getting in and out of bed, hearing or seeing, who may not even who may not themselves think of themselves as a person with a disability. Section 504 still protects their rights under law. Now, in Michigan, we have the People with Disabilities Civil Rights Act of 1976. And much like Elliott Larson, Civil Rights Act is a kind of a state version of the Fair Housing Act, or rather the Civil Rights Act of 1964 and 68. The People with Disabilities Civil Rights Act is largely the Michigan version of the Rehab Act. However, the Michigan PDCRA does remove the qualification that a program receives state funding or be state operated. It provides that qualified individuals with a disability must be provided with reasonable accommodations that do not impose undue hardship, which is where in Michigan we get that kind of first instance of talking about failure to accommodate as a form of discrimination. We'll get into that more here. We also have the Fair Housing Amendments Act of 1988. This is the last major amendment to the Fair Housing Act itself. Certain executive orders, as I've mentioned, can have some bearing on those protected classes written out in the Fair Housing Act. This is the last time it was majorly adjusted. Um, but the Fair Housing Amendments Act of 1988 provides for laws on accessible construction, stating that all covered multifamily dwellings to be constructed for first occupancy on or after March 13th, 1991 must be accessible constructions. Now, there's a rather large guide that determines what is an accessible construction under the Fair Housing Act, but this is the first time that in legislation the idea had been discussed. Now, it's not the case that every disabled person lives in multifamily housing, nor is it the case that all multifamily housing in which disabled people live is constructed for first occupancy after 1991. So how do you achieve that accessibility? You achieve that accessibility through these reasonable accommodations, which are changes to rules and procedures, and reasonable modifications, which are changes to spaces. And as I've been promising, we'll have more on that on the way. And finally, we'll touch on the Americans with Disabilities Act of 1990, known as the ADA. This changes the legal language to refer to disabled and not, quote, handicapped persons, which is what it was up until 1990. Now, the ADA is useful in that if, well, for all sorts of reasons, but for our purposes just now, it broadly defines disability, noting that a condition does not need to be severe or permanent to be considered a disability. It also limits the definition to not include certain specific conditions that had widely previously been considered to be antisocial or otherwise transgressive and disabling in terms of having uh, regular relationships. Things like kleptomania or certain paraphilic, certain other conditions to avoid abuse of the statute's purposes. Notably, the ADA removes sexual orientation as able to be considered to be a disability, and thus it is excluded from protections of disability. Now, for us, Title II, covering public entities and transportation, it also applies to housing operated by state or local governments. And Title III covers public accommodations and commercial facilities. For our purposes, it applies to public utilities and commercial entities such as realty offices, loan agencies, banks, and the like. The ADA further defines a number of standards for accessible constructions, such as specific heights of raised braille signage, width of parking spaces, the height of climate control devices, and much more. But with these 4 key laws covered, we're going to focus now on how disability relates to housing. So, as far as disability in housing goes, the key phrase to remember is the right to full use and enjoyment. Pretty much anything that abridges that right to full use and enjoyment it's a short walk to being potentially discriminatory. And so this next section, we're going to begin with reasonable accommodations. And as I mentioned, it's changes to rules or procedures. And then we're going to get into reasonable modifications, changes to existing structures and spaces, and the how information is relayed through that space, undue burdens, otherwise an answer to the question of what constitutes reasonability. And then finally, we're going to take a look at that practical guide. So, while a person with a disability is protected under fair housing law from all forms of discrimination that may otherwise occur in a housing transaction, things like refusing to sell or rent, different terms on a loan, restricted access to apartment complex amenities. Again, the list is never exhaustive. The most common form of discrimination toward people living with a disability is a failure to accommodate. So that's a failure on the part of a housing provider or otherwise controlling entity to allow for those changes to rules or spaces that would better afford that person their right to full use and enjoyment of the dwelling or property. So yeah, as I said, we'll discuss reasonable accommodations and modifications. We'll look at what constitutes reasonability, and then we'll look at that practical guide of what you might be able to expect during the process of making one of these requests. So once again, a reasonable accommodation is a broad concept. What is needed and how it is provided always depends on the circumstances. And because of that, it's always the duty of the person living with the disability to request the accommodation. Uh, they know their needs best. And so the idea always should be to assist a tenant or, yeah, to assist a tenant or renter or, someone living in this dwelling. The idea is always to assist them to achieve full use and enjoyment of that dwelling, but not by placing an undue burden on the housing provider. And so making reasonable changes to rules, such as if a person has a mobility impairment, they can pay their rent check, they can pay their rent by mail instead of taking it down to the office. The simple change to a rule, policy, procedure, or provision of service that better allows this person to live their life in that housing program. So people with disabilities are not obligated to disclose their disability, and they may choose not to do so unless and until they need some sort of accommodation. Um, it's never appropriate for a housing provider to, see a tenant who's maybe having a slow morning, moving around, and then go out of their way to say, hey, we're going to build a ramp for you. It could be of the best intentions, but it's not their place to say so. And it's, again, crucially incumbent upon the person living with the disability to make that first request. And so while we're on this slide, I want to take a moment to further discuss the difference between an apparent or non-apparent disability. And it's unfortunate, but it does sometimes happen that non-apparent disabilities can be treated with more suspicion by housing providers. So as I said, the need for a wheelchair is easier to prove to an outside observer than the need for an animal that helps manage someone's post-traumatic stress disorder is, for example. So reasonable accommodations then are needed when, again, the person with the disability asks for them. The reasonable accommodation helps them achieve full use and enjoyment of the dwelling, and the reasonable accommodation does not constitute an undue burden. And there's no standard catalog of accommodations as people have unique needs. And for that reason, it's the responsibility of a housing provider to listen to these reasonable accommodation and modification requests in good faith, and to not assume what a person may or may not need, not assume that a person is lying just to circumvent otherwise written rules. It's these requests should be taken in good faith. So support animals, say, are a reasonable accommodation in that the housing provider accommodates the tenant by waiving a no pets policy to allow the presence of the animal or animals in the home. Now, what is needed sometimes is not an accommodation, but a modification. And these are alterations to the physical or informational space that help a tenant in navigating that space. So things like grab bars to help with stability, usually in slippery surfaces such as a shower, ramps to better allow wheeled travel, and then, changes to how a tenant is alerted to the information in their home. A common one here is using flashing lights instead of a doorbell in cases where a person has a hearing impairment. Now, of course, much as is the case with reasonable accommodations, this list is not exhaustive, and it's up to the person with the impairment to determine what modifications best suit their needs. And other examples of these modifications could include widened doorways for wheeled travel, zero-step showers instead of a high bathtub wall. We've got a brief little article on that toward the end of this training. And then finally, reinforcements to the studs of a wall for the later installation of a grab bar. Even though that reinforcement in itself is not accomplishing what the grab bar later will, it still counts as a reasonable modification because it's necessary for that later installation. So it's usually very inexpensive or free to adjust rules and regulations for reasonable accommodation. For instance, the allowing a tenant to mail their check instead of taking it down to the office. But if you're going to install a ramp, for instance, that's going to require time, labor, and materials to construct. All of these have costs associated with them, and these costs can add up. So who pays? Generally, in privately owned housing, the tenant is expected to cover the expenses of making reasonable modifications, unless those modifications benefit the whole building. So if I'm in a privately owned apartment complex and I need a ramp to use the pool, that's a change that's going to benefit the whole building. That's something that probably already should have been done. I'm not on the hook for that cost, even though it directly benefits me, and I've made that reasonable modification request. Because it benefits everyone, the building is responsible for it. Another reasonable accommodation that we see pretty often is allowing a reserved parking spot, usually closer to the building or in such a this new reserved spot is in such a spot that it limits obstacles or the difficulty of the path to get to the building. But changing the rules to allow a reserved parking spot, pardon me, costs nothing. Printing and installing the sign that would then designate the spot as reserved will have a cost, and the tenant may be required to cover those costs. In the case in the case of subsidized housing, such as housing that's in Section 8, housing that's under LIHTC, if the housing is at least partially publicly owned, the housing provider is required to cover the costs with some exceptions. They are under a greater obligation to have to cover those costs. Now, the owner of a modified dwelling may always require that the unit be returned to its original condition, unless, kind of like if the change benefits the whole building, the building pays for it. If the change is neutral, the change does not need then to be undone. So, for example, it may be required by the housing provider that grab bars in the shower be removed at the end of tenancy. Pardon me. If, however, the wall that's behind the shower needs reinforcement, as I was talking about earlier, needs to be reinforced to bear the weight that will later be supported by a grab bar, that reinforcement does not need to be removed. It does not impede the next tenant's right to full use and enjoyment. And so a similar one would be a widened doorway or common area wheel ramps. Those are almost always neutral modifications. Now, in order to save on the associated costs of a modification, sometimes the requester may offer to install the modification themselves, or they might know a guy, The housing provider, however, always has the right to ensure that the modification is carried out professionally uh, and in a workmanlike fashion. And there are now, so reasonable accommodation, reasonable modification. Something that uh, we need to understand then is what constitutes reasonability. So the first thing is that in order to show that a requested accommodation is necessary, there should be an identifiable relationship or nexus of care between this accommodation or modification and the alleviation of the symptoms of that disability. So if it passes that test, then it also must be shown to not constitute, one, a fundamental alteration of a housing provider's program, or to cause an undue financial or administrative burden. So a nexus between is kind of jargony, but it's the characteristic of an intervention that helps to ease the strain on regular life activity caused by a disability. So, for example, a seeing eye dog's ability to lead a person is the nexus between the disability, the visual impairment, and the accommodation, the waiver of a no pets policy. The guaranteed shorter or safer travel distance from a reserved parking spot to the residence, that's the nexus between the disability, a motor impairment, and the accommodation, the waiver of the open parking. And so if that can be demonstrated, what needs to be shown is that it does not constitute a fundamental alteration of a provider's program. This would be something like um, if I am 63 years old, living in housing designated for older persons, and I want an accommodation on the rule disallowing kids under the age of 18 to live in the building, I can create a nexus of care in that, my 17-year-old grandson is very helpful to me and helps manage, the impairments that I live with. But it could constitute a fundamental alteration of the provider's program in that it's senior designated housing. As far as undue financial or administrative burdens, we're going to look into one here in just a moment. So, strictly, you learn whether or not something is an undue burden at the level of litigation, and it's decided by the courts. But this will typically concern the financial resources of a provider, the cost of the accommodation or modification, the planned or potential benefits to who's requested it, and the availability of other less expensive alternatives that would otherwise effectively meet the needs of the requester. So, if, for example, let's say that we have someone who suffers from a chemical sensitivity disorder, and they request, in order to alleviate the symptoms of that, they make a reasonable accommodation request that the owner of the building surveys all the tenants in the building to determine the time of day and the nature of the chemicals they use for cleaning their own units. And she asks that the owner compiles that information and reports it to her so that she can plan to be out of her residence when the stronger chemicals are being used to clean her neighbor's units. That is pretty facially administrative. It's easy to see where that could be an undue administrative burden. Doesn't have necessarily a strong financial burden associated with it, but communicating with all the tenants, logging all that information, sending it over, and the back and forth of administering that accommodation is pretty unreasonable. However, more reasonable accommodation you could suppose would be that the owner speaks to their own cleaning crew, and the cleaning crew, where they're able, uses less volatile cleaning chemicals when cleaning public areas. So that's, it's not exactly as far as the request went originally, but it does, at the end of the day, help to alleviate symptoms in much the same way as the original request. So, just a reasonability recap. Reasonable accommodations or modifications can be requested at any time. Residents with non-apparent disabilities may be asked to provide documentation on why the accommodation is needed. You can request more than one accommodation or modification at any given time. And reasonability is not defined under law and must be determined on a case-by-case basis, often at the point of litigation. It's ultimately up to a judge to determine whether or not that request was reasonable. And so, again, these have been some quick overviews of, what reasonable accommodations are, what reasonable modifications are. And now we're going to take a look at this next section, sort of an outline of what you can expect if you are yourself to go and make a reasonable accommodation request. It's something that I've been doing throughout this training, I think, but in this next section, I might sometimes refer to these accommodations and modifications as interventions. This is not something that's supported in the legal language, but it's for the sake of brevity. But we'll start with the bare bones outline. The first step, and this is something that we recommend here at the center. The first step, we always recommend that you speak to a healthcare provider first for the proof of the nexus of care, or what's called a medical support letter. This is not strictly necessary as far as the law goes, but it can really help in avoiding some downstream headaches when you're trying to get all this paperwork together should your housing provider deny that request. So the second step, or really the first step, but the tenant living with a disability makes the initial request. Ideally, the request is granted. You can wash your hands and move on to the next one. Everyone's happy. Often, a housing provider will challenge the request in some regard. So then you begin what's known as the interactive process. I'll get into that here in a little bit. And then finally, step 6 is if there's no traction or no movement anywhere back or forth, further contact with a healthcare provider to bolster that proof of nexus of care, or reaching out to a fair housing center so that we can advocate on your behalf is where I recommend it at this step. So step 1, speak to your healthcare provider. Now, healthcare professionals, or rather a healthcare provider, is not as broadly construed as some of the other things we've seen, but a healthcare professional can be a doctor, a licensed mental health professional, psychologists and licensed clinical social workers. They could be your therapists, nurse practitioners, rehabilitation specialists, but it doesn't need to be someone who works professionally in the healthcare field in the same way that a doctor does, say. Other qualified individuals include non-medical service agencies. So these would be organizations that provide services to individuals with disabilities, disability-related peer support groups, and reliable third parties. So really anyone who's in a position to know about the person's disability and functional limits imposed by that disability can be a healthcare provider for the purposes of a medical support. Now, at the very least, one of these medical support letters should be on some type of letterhead, not just written onto notebook paper. Even though you could, well, again, not legal advice. I'll stay myself here. But so it should, at minimum, be on a letterhead. Verify the existence of the disability in the requester. Identify the accommodation. And I've written here by name of a support animal. It's maybe the most common request is wanting to keep an emotional support animal through an accommodation of waiving the no pets policy. Including the name of that animal makes it clear that no, not just having like a goldfish, but this my support animal who I have an established relationship with is the one that the nexus of care exists only with, for instance, my dog Bill, and not just any old pet, or excuse me, not pet, any old animal. And then finally, show that the requested intervention does aid in managing that disability. So those are the minimum requirements of a medical support letter. If you can write much better ones by reaching out to the Fair Housing Center, where we have experienced and educated staff who can assist. So step 2, making that initial request. So it can take any form that the requester prefers. Technically, a verbal request is a reasonable accommodation request. And it's always good practice to make these sorts of requests in writing. But a verbal does still begin this process. Some housing providers we've seen in our work will attempt to require the use of one of their in-house forms. They didn't make the request on form ABC7, so it doesn't count. That's not allowed. There's no official form for making these requests, and disallowing a request because it's not made with that particular form is textbook failure to accommodate. And the request should, at minimum, state why the proposed intervention would help manage a disability. So going in and saying, yes, I'd like this reserved parking spot, you don't need to then and you're never under any obligation to speak specifically about your diagnosis, but the request could look like, I would like a a reserved parking spot closer to my apartment because it's hard for me to get around in the parking lot, especially with, the weather that we've been having lately. You, you're at a risk of slip and fall, but you don't need to say that, you have a particular injury to your leg that flares up. Specifics are never necessary in these initial requests. If your housing provider does ask for specifics about your diagnosis, reach out to this or other fair housing centers or some sort of legal representation if you feel it's gone that far. So, step 3, this is the ideal case that the request is granted. It's not impossible that the request will be seen here as reasonable, and the request will be granted at the earliest possible step. Obviously, I'm giving this training, so we know that often this is not the case. So thinking back to what determines unreasonability, undue financial burden, undue administrative burden, fundamental alteration of the housing program, usually whoever is denying a request will make an appeal to one of these. And once they do, you can begin to interrogate what sorts of changes to that request might lessen the burden or not constitute an alteration of the housing program. So step 4, the request is challenged. So the housing provider is within their rights to challenge a reasonable accommodation request as being unreasonable. But in order to do that, they should ask themselves the following questions. And now these following questions I've taken directly from some guidance on how the conversation should look when discussing assistance animals. And again, there's going to be some language about animals specifically, but these 2 questions, asking and answering, applies to the process generally. And so it's a wordy slide. I'm going to make these slides available to all those who joined us today, but it really boils down to question 1, does a disability exist? And question 2, does the requested intervention help to manage this disability? If the answers to questions 1 and 2 are yes, the Fair Housing Act in Section 504 require the housing provider to modify or provide an exception to the rule or policy to permit the accommodation or modification. If the answer to either 1 or 2 is no, then the requirement does not exist. So I've listed once again our chemical sensitivity disorder tenant as an example of an unreasonable request for the reasons that we've discussed. It is an undue administrative burden. But if you're the housing provider who denies a reasonable accommodation request or a modification, it is your responsibility to begin the interactive process. And so what this is having that dialogue back and forth with your tenant who's made this request that, the chemical sensitivity, the cleaning product tracking and scheduling, that's not going to work for me from an administrative standpoint. What can I do that meets your needs as well as mine? As the housing provider, it's your responsibility to ask that question and start that conversation. So consider a tenant with a mobility impairment requests that a motorized chairlift be installed so that they can bypass the stairs leading into their building, and a housing provider just denies the request. Compare that to a tenant with a mobility impairment requesting that a motorized chairlift be installed so that they can bypass the stairs leading into the building. The housing provider denies the request and, however, suggests instead that a lightweight ramp be installed. So meeting in the middle is what the interactive process is all about. And it's your right to have full use and enjoyment of your dwelling. It's a housing provider's responsibility to uphold those rights. And finally, it may be necessary to step outside of that process, bolster the proof, gather further proof of the need of this accommodation or modification, or bring in some outside advocacy. So as I've mentioned, the Fair Housing Center of Southwest Michigan has experienced staff on hand to assist in writing these requests. And continuing the conversation with your healthcare provider at this stage is advisable. We've seen it where basically a medical support letter is not taken as sufficient because the emotional support animal isn't named. So why does it have to be this one, et cetera, et cetera? Going back and getting that other medical support letter, just deepening the corroboration of a third party can help at this stage of the process. And so that is, the minimum steps of what you can expect when making a request. Getting into it, obviously, every situation is different. Each step is going to look quite a bit different based on the request and the provider and how that conversation goes. But I do want to share at this stage, um, this is the story of Daniel Black. He was a tenant in a Lansing building that received public funds. And this is an article from the Lansing State Journal a few years back. And they quote him as saying, "I wasn't seeking anything unreasonable. I needed a reasonable modification to my ground floor accessible apartment. I wanted what everyone else had, access to their bathing and showering facilities. He wanted a bathing and showering facilities that he didn't have to step into. And his subsidized apartment insisted that the cost of installing such a walk-in shower was prohibitive, which constituted for them an undue financial burden. The reasons provided for denial by his landlord and corporate management at Capitol Commons continued to shift as the case went on. Eventually, aided by our colleagues at Southeast and Mid Michigan, which serves the city of Lansing, Mr. Daniel Black was awarded an undisclosed settlement, and the property undertook the reasonable modifications. So I list this here to say that one, these modifications do get done, and two, they can cost you a lot more than you may have otherwise thought if you don't get them done. And briefly, I want to close out the presentation today with just one last look at emotional support animals, because they are far and away the most common request and the most common denial. So a support animal is differentiated from a service animal, which is defined under the Americans with Disabilities Act. And the service animal has stricter regulations surrounding it because it's, excuse me, the difference exists in that a service animal is legislated for its use in public versus a support animal, which service, support, emotional support animals under the Fair Housing Act and Fair Housing Law, these are all the same. And what they are is any animal individually trained to do work or perform tasks for the benefit of an individual with a disability. So when a tenant indicates a need for a service animal or a support animal, the housing provider can, especially in the case of disabilities that are non-apparent, request that that tenant provide a letter from a healthcare provider verifying that the tenant has that disability, which requires the presence of the animal. We've gone over this. Courts, however, have ruled time and again that licensing or certification of service animals is not required so long as the tenant demonstrates that the animal provides necessary assistance. And I bring this up because some internet services will offer emotional support animal certifications for a fee, but because licensing or certification are not required, neither are they sufficient. If a service is selling certifications without input from a healthcare professional, it should not be relied upon. That said, of course, there's telehealth services. BetterHelp sets people up with, or I'm not doing ads, but there's telehealth services that that may be able to provide that appropriate information, provided that there is a history of care. Now, importantly, the housing provider cannot inquire specifically about the disability a person has or the services that the animal provides. And while many support animals are dogs, they can be any type of animal. And again, this has been borne out time and time again by fair housing case law nationwide. They don't need any special harnesses or tags. They also, again, and crucially, don't need to have any sort of special certification or licensing. And in some cases, an individual with a disability may require more than one support animal. And all that's required there is that there be a nexus of care established between that animal and the symptom of the disability that they help manage. So that is, the animal provides some function that excuse me, I just said that. The proof then that a requester must present is a healthcare provider's acknowledgement of this nexus for each animal. Uh, yes, and again, the accommodation is the lifting of a no pets policy. Support animals are not pets and are therefore not subject to attendant fees, size restrictions, breed restrictions, etc. They're a tool, not a pet, and uh, if you need them, you're allowed to have them. That takes us to the end of today's training. If you do have any questions, and you'd like to drop them into the Q&A box, we've got a little bit more time. And if you do not have questions, feel free to hop off of the call. I'm going to leave our contact information up. And if no questions are forthcoming, I will shut us down here in just a moment. Thank you again, everyone, for joining today.